Getting old is a privilege, and it really is a privilege that most of us would like to strive to. And in terms of powers of attorney, you find that sometimes our senior citizens or elderly persons may grant a power of attorney to a person to act on their behalf. And essentially what a power of attorney is a legal instrument which allows a person to act on another person's behalf. And the power of attorney usually sets out what is the authority the person possesses. So it would say whether the person is able to make deposits, whether the person is able to make withdrawals, whether the person is able to make investments on behalf of the elderly person. And usually it is a registered power of attorney, particularly in our jurisdiction. So why it is an issue, particularly from the banking perspective, is that it can sometimes be used as a vehicle for elder financial abuse. And sitting as the chair of the legal committee, sitting as a banker, sitting as someone who works in the banking industry and provides advice in relation to these matters, I really think it is important for us to have this type of conversation. I think that it is important for the public to be aware of the issues arising in relation to the use of powers of attorney, particularly for elders, and to really generate an environment where all persons, including our senior citizens, feel comfortable to raise an issue where they see, their power of attorney is being misused. So really and truly kudos to BATT for creating this environment and sensitizing the public. There is no recommended age or signs. It is more situational. So if it is a situation where there is a need for someone to be appointed to act on behalf of an elderly person, then a power of attorney is an option. What we must always consider is the mental capacity of the person granting the power of attorney. But mental health issues really transcend our operation as a society. So if the elderly person or the senior citizen who is granting the power of attorney is not mentally capable to handle their financial affairs, a power of attorney is not an option. In that instance, a more appropriate option is to go before the court and have a court order be issued appointing someone to act on behalf of that elderly person. Once the elderly person has the mental capacity to act on their behalf in terms of their financial affairs, the power of attorney is open for use. I would suggest that the power of attorney outlines specifically what are the authorities that the person who is being appointed via the power of attorney, what they are able to do, whether they are able to deposit and withdraw but nothing else, or whether they are able to have ATMs, digital banking access, etc. And all of those things should be itemized in the power of attorney. It is an option as well to limit the power of attorney to a specific time period, so it can state specifically that it's going to be terminated on X date, whether it's July 1st, 2022 or another date. Or it can be general and have no limitations in terms of time. But once we all know that the power of attorney ceases to be valid once the person who grants the power of attorney revokes it, or the person who grants the power of attorney dies, or the person who grants the power of attorney becomes mentally incapable, or the same factors applies to the person who has that power of attorney. So I wouldn't say that it is dependent on an age or stage, but it's more of a situation. If they are just not able to attend the bank and transact on their behalf due to being out of the country or physical limitations, but they still have the mental capacity to do it.